So this webinar is the second of a series, and it's co-hosted by Green Member of Parliament Diana Ribaeginer, who's here today, with Fair Trials, co-hosted by Fair Trials and co-hosted by Prison Insider. It focuses on pretrial detention in the European Union. As Director of Prison Insider, I'm happy to moderate the session. Prison Insider is an information platform on prisons in the world. We inform, we compare, we share testimonials on conditions of detention with regard to fundamental rights. Thank you, Diana, for the opportunity to have this webinar. So today's discussion will focus on pretrial detention. Holding people in prison before they've been convicted is planned to be only an exceptional measure, and it's supposed to be used in compliance with the presumption of innocence and the right to liberty. But what is observed in the world is that pretrial is widely overused, and this is also the case in the EU, where we see that prison overcrowding is largely driven by the excessive use of pretrial detention and that it has severe consequences on detention conditions. So today's discussion will be an open exchange on what can be done, what does the EU do, and what should be done to address the issues around pretrial detention. Diana, I'd like to give you the floor for the welcoming words, and then after that, I'll introduce the panelists. Diana.
Thank you very much, Florence. Good morning, everyone. And I will speak in Catalan, so please you can change the interpretation now if you need it. Bon dia a tothom i gràcies per acompanyar-nos avui en aquesta conferència. En primer lloc, m'agradaria donar les gràcies a tots i totes les ponents per ser avui aquí amb nosaltres i per haver acceptat aquesta invitació. També vull agrair a l'equip de Prison Insider i de Fair Trials la coorganització d'aquest acte i també a tots i totes el que fan possible que es puguin fer aquests webinars des d'equip tècnics fins als intèrprets que ens posen veu amb tots els idiomes. Per tant, moltes gràcies. Aquest és el segon d'un seguit de webinars, com bé ha explicat la Florence, que tenen l'objectiu d'impulsar la legislació europea en matèria de presó preventiva i de condicions penitenciàries. Avui, doncs, tindrem l'oportunitat d'escoltar diferents perspectives que ens ajudaran a entendre i a saber avançar i a corregir les diferències, però sobretot els abusos de la presó preventiva a Europa. Perquè, tal com preveu el dret internacional, la presó preventiva, i com ha explicat també la Florence en la seva intervenció, hauria de ser una mesura excepcional, d'últim recurs i utilitzada en circumstàncies molt limitades. Però, en canvi, la tendència mundial, no només a Europa, va en direcció contrària. Des de l'any 2000, l'ús de la presó preventiva s'ha disparat al món i és insostenible i humanament inacceptable que el món tingui més de 3 milions de presos o preses preventives. Si bé és cert que en Europa és una excepció en aquesta dinàmica, encara són moltes les persones que viuen en presó preventiva dins la Unió Europea i ho fan amb una gran disparitat dintre dels estats de condicions, de permisos, de límits d'any, segons aquest estat membre on es trobi. La presó preventiva en aquests moments s'ha convertit en viure dintre d'uns llimbs. Jo entenc la presó preventiva com una espècie de buit o de forat negre on no tens sentència condemnatòria ni ets un pres formal. I la conseqüència d'això és que els presos i preses en les presons en Europa no tenen accés ni a activitats, ni a plans de rehabilitació, ni a formació, ni a poder treballar dintre les presons, ni a permisos. Per molt dur que soni, dir-ho, la presó, però sobretot la presó preventiva, és deshumanitzadora des del nostre punt de vista. I es tracta d'un abandó, i es tracta d'una desprovisió de les necessitats d'una persona, de les necessitats vitals d'aquesta persona, amb conseqüències que poden ser irreversibles i també amb conseqüències irreversibles dintre del seu entorn familiar o dels seus fills o filles, tal com denuncia l'organització Children of Prison of Europe. Amb tot això, s'hi suma que la presó preventiva agreuja la problemàtica de la superpoblació penitenciària, que conseqüentment empitjora les condicions a les presons i posa obstacles al funcionament dels instruments de cooperació judicial, com poden ser les euroordres o la decisió marc de trasllat de presos entre estats membres. Al nostre entendre, és a partir d'aquest punt, que he explicat ara al final, aquest angle precisament que la Unió Europea pot actuar. La problemàtica de la presó preventiva té una dimensió europea i una base legal a la qual corregir les deficiències existents. Però per conèixer aquests detalls i per acabar, tindrem la possibilitat d'escoltar amb molt de gust a experts i a persones com, per exemple, l'Edu Ramírez, que ho ha viscut en pròpia persona. Per tant, gràcies a tots i benvinguts a aquest segon webinar, que segur que es podrem disfrutar i entendre més el que és la presó preventiva en aquests moments dins la Unió Europea. Gràcies a tots i totes.
Thank you, Diana. As you said, today we have a very distinguished panel composed of 4 experts. I'll introduce them briefly before then giving the floor to each of them. Laure, welcome to you. Laure Baudrier-Gérard. She's Fair Trials Legal and Policy Director in Europe, and she works on the organization's engagement with European regional authorities. Vania Costa Ramos is a criminal lawyer in Portugal. She's a CPT member, and she's vice chair of the European Criminal Bar Association. We then have Adu Ramirez is an Altasu youth representative. And in 2016, he had the experience of a fight in a bar and then was imprisoned for at least for a little less than 2 years in pretrial detention. Jesca Beneder, she's the team leader of the European arrest warrant, working on detention for the European Commission with the DG Justice. So for today's talk, we plan to have 1 hour. That means it's rather short. All panelists will keep their presentation as short as possible to leave some time with for the Q&A. All the other participants have their microphones muted by default, so you're invited to send your questions in the Q&A section at the side, and we'll pick a few of them for the discussion at the end. I'll start with a question for you, Laure. We know that fair trial advocates for pretrial detention reformed, and you've published a study highlighting also the gap between practice and the law in 10 EU countries. But how does overuse of pretrial detention violate people's fundamental rights?
Thank you very much, Florence, for the introduction, and thank you to Diana and Saskia and all of your colleagues for organizing and hosting this discussion on pretrial detention. And in your introductions and highlighting already how important this discussion is, and even if it's just limited to an hour, hopefully this is just part of an ongoing conversation. So just a few words first to introduce Fair Trials. Fair Trials is an international non-partisan NGO that campaigns for fair and equal criminal justice systems. And Fair Trial has long advocated for reform on pretrial detention. So as Florence mentioned, we conducted a few years ago a study in 10 member states evidencing the failures in the pretrial decision-making process that leads to the overuse of pretrial detention. And I say overuse in the sense that pretrial detention is supposed to be an exceptional measure of last resort, as Diana referred to, but our research showed that it is used routinely and it is applied disproportionately to non-nationals and non-residents and to people from racialized and ethnic groups. And yet the decision to order pretrial detention has an impact on people who are detained that is simply immeasurable. And I'm sure Archer will describe this much better than me, the extent to which their family lives can be impacted, employment prospects, reputations can be destroyed. And it is quite simply one of the harshest measures that a state can take against an individual. And this practice, the overuse of pretrial detention, needs to stop. We need to prevent unnecessary and disproportionate recourse to imprisonment. And this should be the priority in Europe's criminal justice policy, because limiting recourse to pretrial detention would contribute towards reducing prison overcrowding and protecting people's fundamental rights. Europe's prison overcrowding crisis is long-standing and causing poor prison conditions that have been documented repeatedly, including by the European Court of Human Rights, which in the past decade has repeatedly condemned EU member states for their poor prison conditions linked to overcrowding. Last year, for instance, in relation to French prisons. But despite these regional international standards that exist, overuse of pretrial detention is continuing to fuel this prison overcrowding crisis, because we see in the EU that our prisons are filled with people who have not yet been convicted of any criminal offense. So at any one time, today, there are 100,000 people on average who are in prison waiting for their trial. That's 1 in 5 of the total EU prison population. And these numbers have consistently grown over the past few years. Last year, with the COVID-19 crisis, we had hope that this trend would change. We faced the immediate risk to health and to life of putting a person in detention, where social distancing in overcrowded facilities to prevent the spread of the virus was simply impossible. But although some member states did take steps towards releasing sentenced prisoners, we didn't see actions towards releasing people in pretrial detention or preventing new entrants into pretrial detention. We did see some positive judicial practices that led to some reductions, but this happened at the beginning of the pandemic, and we saw again in many member states the rates increasing as the year progressed. And this has huge implications on the fundamental rights of people. Fundamental rights enshrined in the EU Charter. Prison monitoring authorities' reports repeatedly show how overcrowding is causing cramped and unhygienic accommodation, is causing constant lack of privacy, reducing activities and time for prisoners out of their individual cells. It's limiting access to healthcare services. It's increasing violence between prisoners and between prisoners and staff. The World Health Organization estimates that 25% of prisoners face violence. And of course, a lack of availability as well to all the key social services that would enable a person to reintegrate society. And for a person who is presumed innocent, who is awaiting trial, overcrowding is preventing their ability and detention itself to prepare adequately for their defense. It's the pretrial detention places the person under huge pressure, creating a massive imbalance between the defense and the prosecution. And the continued increase in pretrial detention, in our view, should be treated as a sign, as a red flag that there's a problem with the rule of law in Europe, because failures in the rule of law cannot be assessed only in respect of high-profile political cases, but also where our criminal justice system is failing to protect the most vulnerable. Because if people are being unnecessarily placed in pretrial detention, this indicates a failure of the mechanism in place to uphold the rule of law and protect people from excessive use of state power. And high pretrial detention rates, as we see in Europe, are a sign that the limitations to the use of state power are not being respected, and that people are not able to access justice. They're not able to exercise their right to an effective remedy. They're not able to access impartial and independent courts and seek judicial protection. So today, we reiterate our call for the EU to act. The COVID-19 pandemic continues to create an urgency. And we can start by learning by some of the pockets of good practices we did see. In Belgium, for instance, there was a reduction by investigative judges placing new entrants into pretrial detention, although that changed later in the year. There was also evidence in the Netherlands of prosecutors refraining from making pretrial detention motions, taking into account arrested persons' underlying health conditions or even the health conditions of their close family members. But these individual pockets of practices need to be turned into sustainable policy. And the EU has a leading role to play here on the global stage, because as you highlighted, the overuse of pretrial detention is a European but also global problem. And last month, I'd like to point towards the UN, which adopted a common position on incarceration, recognizing the global use of imprisonment generally, with prison seen as a response to all sorts and more social ills, even COVID-19 offenses. And the UN describes prisons as the weak link in the criminal justice system due to over-incarceration, due to overcrowding, poor conditions, and the serious neglect of prison services. And in fact, one of the UN's Sustainable Development Goal on peace, justice, and strong institutions is the percentage of pretrial detainees within prison populations, which should be used as an indicator for measuring the efficiency of our justice systems and access to justice systems. The EU also recognizes that pretrial detention is a complex issue to address. It is complex, it involves many actors, many stages of the proceedings, but it's not because it's a challenge that we should ignore it, ignore the human rights violations that overuse is causing every day in Europe, and keep on going with this ever-increasing growth trend in recourse to prison at pretrial stage. And here I'd like to conclude on how EU action is long overdue. The Council had asked for common EU standards back in 2009. The Commission announced legislation in 2011, but since then there has been no proposal, despite repeated requests from the European Parliament and despite very strong signals recently from the EU Court in Luxembourg. I'd like to quote Attorney General Pietruzzella, who said that the EU legislature must urgently address the question of harmonization of pretrial detention, as it is ultimately, and I quote, the European area of criminal justice that is under threat. Now, of course, we recognize legislation on its own will not solve this problem. This will ultimately require cultural shifts in prosecutors and judges' attitude to imprisonment, to public safety, to risk. It will also require structural change to address the prejudice and the bias that means that some people are treated less worthy of legal protection and too risky for release. But starting with clear EU legal standards could kickstart this work, and we urge the EU to take the global lead and seek to create and amplify good practices on the reduction of recourse to incarceration, because this is key to reducing prison overcrowding, improving detention conditions, and protecting fundamental rights in Europe and beyond. Thank you very much.
Thank you, Lo. Thank you very much. I'd like to turn to Vania now. Vania, as a criminal lawyer, you're very frequently called to advise people facing pretrial detention, and in particular, those including cross-border proceedings. Can you tell us how do different pretrial detention standards affect cross-border judicial cooperation? And what do you think about the way that safeguards can be harmonized throughout the European Union? Vania, you have to open. Thank you. Lovely.
Good morning. Firstly, thank you very much for the invitation, and apologize me for my deficient Zoom technical abilities. So I think it is quite clear from my practice that there are issues around the operation of cross-border proceedings and of safeguards in the field of pretrial detention, and mainly the European arrest warrant. And I always think that the best way to show that is just to give you an example of a case. A striking example for me, and one that is easy to describe in a few minutes that I have, is a case I had a few years ago in which a German citizen came to live to Portugal with his wife. He did change his address officially in Germany to Portugal, but he did not give the information explicitly in the criminal case. So, but he did register in the civil register, no explicit information. However, he did have a lawyer instructed in his criminal case that was pending. One day he is arrested in Portugal pursuant to a European arrest warrant. The facts were the possession of a few plants of cannabis in Germany a while ago. He was incarcerated overall about 1 month. And the case was very low. It was not a serious case. So at the time, I tried to help him together with a lawyer in Germany, okay, which I could find because he did have a lawyer, and I do speak German. So it was possible to communicate with this lawyer. And we tried throughout the time where he was in pretrial detention in the European arrest warrant case to obtain his release. and the withdrawal of the European arrest warrant, because the German lawyer said it is clearly not a case for pretrial detention. We could not make it, despite the efforts of the German lawyer making applications in Germany to the courts. We could not avoid that he was surrendered. So when he was surrendered to Germany, the following day, he was brought before the judge and released with a financial security of 1,000 euros. So this is a very practical example of a situation in which pretrial detention was completely unnecessary, because if all the normal or the alternative procedures would have been used, he could have just paid the financial security anyway, without having to go in prison to Germany. And also, if the cross-border aspect of the European arrest warrant proceedings, namely, for example, if he could have been interviewed by the German judge during the proceedings before being removed to Germany, he would have been released without the need of being extradited. And of course, as Laure mentioned, he was in prison for 1 month because he did not fight the case, but this could mean losing a job and all sorts of different consequences. If people have small children, it could also mean that the children have issues, they have no carer, or they have difficulties. So this has real impact in persons' lives. And it shows what, for me, is a real problem, which is the fact that pretrial detention often has as a reason the fact that the person is a foreigner or is moving abroad. And this, in the context of the European Union, makes little sense when the persons are moving within the European Union. Often it is not an escape. There could be cases where that is the issue, but it's simply because people, for financial reasons or family reasons, move to another EU member state. And this is an issue that, in my view, needs to be addressed. And also, there is a need to improve the safeguards around access to legal assistance. Normally, it is difficult to get a lawyer in the issuing state. This was a case where the person was lucky because they found a lawyer in Portugal who spoke German and who could communicate, and they already had a lawyer in Germany. But in other cases this is simply not possible. So we could not do anything to try to avoid the surrender to Germany anyway, because of lack of operating safeguards in practice. So I think this is a good example. I think I kept within my time. We can go and speak more about other issues, namely, of course, this is not only an issue of excessive pretrial detention. It is an issue of the impact it has on other procedural safeguards. If you are in pretrial detention, if you remain in pretrial detention, then it is much more difficult to organize your defense, to have access to a lawyer, to consult your case files, to prepare the defense, to consult your family, and so on. So pretrial detention has a huge impact in the way that a person can fight his criminal case. And also, of course, it has a huge human impact for your life outside prison, but also your life in prison, because, and that I can say from my practice more as a CPT expert than as a criminal defense lawyer, that the conditions in which people are held in pretrial detention are often not to the standards of European legislation and soft law recommendations, meaning that there is not enough space, poor material conditions, in some places many restrictions to the contact with the outside world, lawyers and family relatives, lack of activities, lack of any meaningful possibility to avoid the deleterious effects of detention. So I think we have another speaker who can put this in a more colorful manner. So I hope this is enough from my side.
Thank you very much, Vania. Indeed, your points are very, very powerful, and I'm sure that they resonate strongly with you, Adur. You've spent, as I said, nearly 2 years in pretrial detention in Spain. Can you share with us what was your experience of that detention? What access did you have to legal representation? Were you able to maintain contact with your family, with your friends? Were you able to pursue your studies? The floor is yours. You have to unmute.
Ahora. Vale. Bueno, buenos días. Yo soy Adur. Intentaré explicar lo más breve y sencillamente pues, la experiencia que he pasado durante estos 4 años casi. Y bueno, por poner en contexto un poco el caso, pues yo creo que hay que explicar de dónde viene, ¿no? El caso Alsasua, no sé si la mayoría de la gente de aquí lo conocerá. Pues es un caso que, bueno, en noviembre de 2016 hubo un encontronazo en un pueblo de Navarra con agentes de la Guardia Civil y unos jóvenes del pueblo. Y lo que al principio parecía pues un encontronazo como otro cualquiera y hubo 2 detenciones que se investigaron en su momento como atentado de autoridad y lesiones, o sea, como delitos comunes, pues ya desde el momento cero de ese momento pues bueno, se interpuso una querella en la Audiencia Nacional por un colectivo de víctimas del terrorismo del Estado español y bueno, este colectivo de víctimas en esa querella pues planteó la posibilidad de investigar este delito o este acontecimiento como un delito de terrorismo, ya que ellos entendían que se había acometido o se había producido ese encontronazo por motivos políticos y dentro de una dinámica política en la que ellos pues, veían que era una parte más de la dinámica de ETA, ¿no? Entonces, bueno, para explicaros mi experiencia personal, una vez ya habiéndose producido las 2 detenciones en el momento, pues en el momento que se liberó a estas 2 personas, puesto que estuvieron solamente 2 días en comisaría, nosotros, los demás compañeros de causa que somos ahora, pues nos dimos cuenta de que nuestros nombres aparecían en ese listado, ¿no? En el sumario policial. Y desde el momento en el que nosotros sabíamos que nuestros nombres se encontraban en ese listado, pues fuimos voluntariamente a declarar en el juzgado de Pamplona, puesto que en ese momento todavía se investigaba como delitos comunes. Lo que pasó fue que no nos tomaron declaración y nos dejaron irnos como si nada hubiera pasado. Hasta que, como ya he dicho, la querella de Comitè llegó a la Audiencia Nacional y la Audiencia Nacional pues, emitió una orden de detención contra todas las personas que estábamos en ese listado de nombres y se efectuaron las detenciones de mis compañeros. ¿Qué pasó? Que a mí personalmente no me detuvieron. Entonces fui voluntariamente por segunda vez a la Audiencia Nacional para prestar declaración y tampoco me tomaron declaración. Porque pues, se entendió que no llegaba en el horario que la jueza trabajaba y bueno, me dejaron a mí también irme de vuelta. En ese momento, en noviembre, pues los demás compañeros de causa fueron encarcelados y a mí se me hizo un nuevo llamamiento para ir a declarar 2 días después. Entonces ya fui 2 días después a declarar, que sería la tercera vez que fui a declarar voluntariamente y después de esa declaración ya pues, se decretó mi ingreso en prisión provisional bajo el pretexto de que tenía un riesgo de fuga y que existía riesgo de que volviera a delinquir, según la jueza, ¿no? Entonces, bueno, pues ya aquí se ve, ¿no? Que ya fui no una, no 2, sino 3 veces a declarar voluntariamente por mi parte y, pues bueno, se decretó una orden de prisión preventiva pues con esas razones, ¿no? Motivando de esas razones. Entonces, bueno, ya una vez empezó esos días de prisión preventiva, eso fue en noviembre de 2016 y el juicio pues, se celebró en abril de 2018, o sea, 1 año y 5 meses después de ese ingreso en prisión. Entre tanto, pues por parte de mi defensa sí que se solicitó varias veces que se me dejase libre, ¿no? Pero todas las veces fue denegada por el motivo de, pues como anteriormente ya he dicho, de riesgo de fuga, ¿no? Y bueno, por hacer un poco una cronología de cómo fue esos años de prisión preventiva, antes se ha comentado que que estuve un total de 2 años y poco en prisión preventiva, pero bueno, ahora explicaré el total de tiempo que estuve en prisión preventiva. Es cierto que hasta el juicio pasó 1 año y 5 meses de esta prisión, pero entre la sentencia en primera instancia hasta el fallo definitivo que viene después del recurso de apelación y luego el recurso de casación al Tribunal Supremo, pues pasaron un total de 2 años y 11 meses. Entonces, ahí, como antes Diana ha explicado muy bien, los presos preventivos, pues hasta el momento de que seamos ya condenados en firme y nos clasifiquen, pues no gozamos de ningún derecho, ni ninguna oportunidad de acceder a cursos, acceder a permisos, acceder a progresiones de grado. Entonces nos encontramos en ese limbo pues con prácticamente ningún derecho y esperando a que nuestra situación se formalice, ¿no? Y en mi caso pues fue eso. Se produjo el juicio, nos condenaron a un total de 12 años, luego ya después de las vistas de apelación y del recurso de casación, esas penas pues se reducieron un poco hasta un total, a mí me condenaron a un total de 8 años y 6 meses, pero bueno, con las reglas de aplicación de penas del Código Penal de España, pues se me quedaba un total de 7 años y 6 meses de cumplimiento. Bueno, no lo he comentado, pero en el momento de que nos procesaron por terrorismo, ya automáticamente nos introducen en un fichero de internos de especial seguimiento, FIES, denominado FIES, y eso, bueno, eso se les introduce en este fichero a los participantes de bandas armadas, con lo que todo ello supone, ¿no? Pues que unos controles muchísimo más estrictos, todas las conversaciones y comunicaciones se nos son intervenidas, llamadas telefónicas, visitas, etcétera, y automáticamente se nos conduce a módulos conflictivos. Hay que destacar también pues, que en las prisiones del Estado español los departamentos o los módulos donde conviven los presos son diferentes, están pues bueno, clasificados de manera diferente para presos reincidentes, presos sancionados, presos que son primerizos. O sea, están un poco, se supone que va acorde a la personalidad de cada interno, ¿no? Pues en nuestro caso, eso, yo entré con 21 años, se supone que deberíamos de estar en módulos de jóvenes y módulos de primerizos, porque era la primera vez que entramos en prisión y bueno, y no fue así porque directamente ya se nos mandó a ese tipo de módulos conflictivos en las que conviven pues, presos con sanciones, reincidentes y gente pues, que no era su primera vez, ¿no? que pisaba la cárcel. Y en cuanto a las condiciones de la cárcel, pues eso, ya aparte de esa introducción en el fichero de especial seguimiento, pues teníamos un montón de restricciones a la hora de meter dentro de material de estudio, por ejemplo, porque había un control muy estricto de los paquetes. En ese momento yo estaba finalizando los estudios de magisterio y sí que tuve problemas pues, a la hora de terminarlo, puesto que no pude terminarlo. En cuanto a las visitas, pues eso, teníamos visitas semanales con amigos y visitas mensuales con la pareja o familiares en vis a vis, pero eso no hay que olvidar que todas esas visitas también estaban intervenidas y bueno, pues, y lo que supone, ¿no? en la intimidad al final de la persona. Bueno, tengo que mencionar eso, que la justificación de la prisión preventiva, antes se ha dicho, ¿no? Cómo se justifica legalmente también y la regulación procesal penal del Estado español también está regulado de una manera muy tasada y muy restrictiva, pero lo que en la realidad sucedió fue que unos hechos que para nada encajaban en esos supuestos, pues forzosamente, pues, por parte de la Audiencia Nacional, pues se nos dijo que eso, que teníamos riesgo de fuga, teníamos riesgo de volver a delinquir y bueno, pues como vimos, estuvimos un total de 3 años hasta que se nos clasificó hasta la hora de poder entrar a gozar de los derechos que la ley penitenciaria nos concede, ¿no? Y bueno, no sé cómo voy de tiempo. Ahora por comentar la situación en la que estoy ahora mismo, pues estuve en prisión preventiva 3 años, la manera de que en el momento ya de que se me clasificó, pude acceder a los 6 meses al tercer grado y ahora mismo pues me encuentro en una situación de de semilibertad con la pulsera telemática y una vez ya rebasado la mitad de la condena, ¿no? De esos 7 años y medio que he comentado. Y bueno, no sé, por mi parte es eso. Luego estaré encantado de responder a las preguntas que surjan y más o menos por poner encima de la mesa, esa es la situación en la que ahora me encuentro.
Thank you very much, Adur, for this very strong story. I'd like to turn to, and I'm sure there will be a lot of questions. I'm not. I'd like to turn now to Jesca Beneder. You're the European Arrest Warrant Team Leader with the European Commission. Can you try, in a few words, to explain cross-border proceedings? And can you say more about how the Commission addresses pre-trial standards at the European level?
Yes, thank you very much, Florence, also for inviting the Commission to this very important event. As you know, we have been working for many years already on the topic of pretrial detention. We performed a comparative law study on pretrial detention in 2015. That study was complemented in 2016 by a study of fair trials, and in 2017 by the so-called Detour project, which focused on 8 member states. Indeed, I mean, that was also mentioned by law. Indeed, the issue of pretrial detention was already on the agenda also in the Stockholm program. However, I have to specify that there was not an explicit request of member states at that moment to propose legislation. There was a request to publish a green paper, and that's also what the Commission did. And based on the outcome of the replies to the green paper, the Commission decided not to propose legislation at that stage. The studies that we have performed over the last year, they indicate that overall the member states, the EU member states legislations, they do conform to a reasonably high degree with the case law of the European Court of Human Rights and the Council of Europe recommendation. It is nevertheless the case that in practice there are significant shortcomings, and that's then notably in relation to the requirement that pretrial detention should be used as a measure of last resort. The studies also demonstrate that it's important not to see the frequent use of pretrial detention as an isolated problem, which relates to legislation only. Pretrial detention decisions have to be taken very quickly. Normally, pretrial detention hearings, they generally only take around 10 minutes, which also might affect, obviously, the quality of the reasoning in case of a high workload of judges. What we see also from the studies is that there is in many member states, there's a culture of ticking boxes, where judges use standard grounds in the criminal procedural code for imposing pretrial detention, such as, for example, flight risk or risk of reoffending, tampering with evidence, or a very large ground existing risk to the public order, without really supporting these grounds with specific evidence related to the particular case. So what the studies do demonstrate is that the issue of pretrial detention can only be addressed as part of a wider strategy in the justice area, and that would then also need to include reforms of the investigation and the trial phases in criminal proceedings, also aimed at speeding up the criminal procedures in the member states. It is probably also for this reason that pretrial detention is perceived by the EU member states as a very sensitive and complex issue. Any EU interference would go to the heart of the criminal procedural laws of the member states. Very recently, we have launched a new study to obtain more evidence on the impact of diverse pretrial detention rules on mutual recognition instruments such as the European Arrest Warrant. So far, we have mainly seen, also in the case law of the Court of Justice of the European Union, refusals of a European arrest warrant based on material detention conditions, and not so much yet on diverse procedural rules on pretrial detention. We have recently consulted the member states again in the Council Working Party in the COPEN on the issue of EU action in the field of detention by way of a questionnaire. We haven't received all the replies yet, but a first analysis reveals that most member states are not very supportive of EU legislation, but that they would be more keen to see non-legislative action in this area. In any case, as I said, and was also followed from the studies, legislation alone will not be enough to address the issue of pretrial detention in a sufficient manner. So we in any case, we need to work on different strands. So national rules, they will only work if they will be supported by the appropriate practical measures too, such as, for example, guidance on decision-making practices, so that the imposition of pretrial detention does not become a rubber stamping exercise as it is actually right now. The study had therefore also identified several non-legislative actions that could be taken in this field, and I will mention some of these. Well, as we all know, also mentioned by the previous speaker, the basic principle is that the detention of an innocent person offends the right to liberty, and that at the pretrial detention stage, any suspect is presumed innocent. So pretrial detention should be a measure of last resort, why alternatives should be considered first. What we see is that alternatives to pretrial detention, such as, for example, bail, electronic monitoring, or an obligation to report to the police, are very often not used in practice, although they exist in many legislations across the EU. The use of the alternatives to pretrial detention by the member states should therefore be encouraged. It is in that respect also very interesting to see what new technologies can offer. Electronic monitoring can open up new possibilities to avoid pretrial detention. People can keep their job or continue their education and care for their families. And the practice of electronic tagging has also greatly improved since the development of the GPS technology. We think that it will be very useful to share data and to learn from each other's experience, positive experience. These exchanges of good practice, they can also be very interesting to find out why some alternatives do work in some member states, but not in other member states. One example would be, for example, release in bail, which is a very successful instrument in the common law countries, and also even seems to exist in many legislations of the civil law countries, but is in practice never used. So what we see is that in the common law countries, there's a presumption in favor of bail, and electronic monitoring has now become a valuable alternative to pretrial detention, while the former technical issues have mostly been solved. However, only providing alternatives, as I said, in legislation will not be enough, but member states should also make sure that they have the appropriate structures, such as, for example, probation service, who can supervise the execution of the alternative sentences. And if you look at the situation in Europe, we see that currently, for example, in Greece, there are only around 65 probation workers for the whole country, compared to more than 1,000 in Belgium and Sweden, which have similar population rates. So there's a lot of work to do also for the member states in that area. It would also be useful to raise awareness. That was also one of the outcomes of the study of judges and prosecutors on the basic principles, which should be taken into account in the pretrial decision making. For example, which are the grounds on the basis of pretrial detention can be ordered. We see many member states will still use the severity of the offense as a ground, which is not an official ground as recognized by the European Court of Human Rights. We have a very extensive case law of the European Court of Rights. We have a lot of recommendations by the Council of Europe, such as the very detailed recommendation of the Council of Europe on remand in custody. The only thing that will be needed is in that area is appropriate training and raising awareness of judges in an accessible way. And the EU can also help with that. I mean, by, for example, providing guidance in that area. I think I have used all my time, so I will stop here. Yeah, just to say that the Commission is very happy to work closely with the European Parliament on these matters, also in the coming months, also in the context of the newly set up working group on detention. Thank you very much.
Thank you very much, Jesca. A very complex issue indeed that you've explained in rather simple words. Thank you. I would like to start with the Q&A. Thank you to everyone. I know we have one participant who's asked for the floor, and he's the Member of Parliament, Fernando Barena from the Left Group. Fernando, would you like to ask a question or to make a few comments? I think the technical team needs to give you access. Maybe while that's done, I'll start with listing a few questions. No, Fernando is here. Please, the floor is yours.
Sí, ya estoy aquí, ya funciona. Ya. Muchas gracias. Buenos días a todas y todos. Gracias por organizar este webinar, Saskia, Diana, y un abrazo particular a Dur por la cercanía. Bueno, simplemente, muy brevemente, para decir que la previsión preventiva es una figura que tan solo debiera utilizarse en casos de fuerza mayor, cuando existen impedimentos, pues eso, mayores, que hacen que el detenido esté en peor situación ante la justicia que en libertad a la espera de juicio, ¿no? Y mayoritariamente su uso frecuentemente indica que el sistema judicial está lejos de ser garantista. Y además, como ya se ha dicho, viene aparejado una situación de privación de libertad donde todo es provisional, que es una de las peores situaciones que puede vivir alguien que esté en prisión por la inestabilidad y por la falta de certidumbre, etcétera, etcétera. Y por lo tanto, tus derechos y calidad de vida pues, se ven perjudicados dramáticamente, ¿no? Quisiera decir que en el Estado español la prisión preventiva además se ha venido utilizando como elemento de presión y castigo en el caso vasco, en el caso catalán y en otros casos de disidencia política y social. Aquí, por ejemplo, en el País Vasco es frecuente conocer personas que han estado 4 años en prisión preventiva, que luego han sido absueltas o cuyos casos han sido sobreseídos y además sin que luego haya lugar a ningún tipo de posible indemnización, ¿no? Y en este segundo aspecto de la vida en prisión, un preso preventivo, como ya he dicho Adur, pues tiene un régimen, unas condiciones mucho peores que un preso condenado, porque está apartado en módulos preventivos, porque no tiene posibilidades de hacer una vida pues con acceso a recursos educativos, de progresión penitenciaria, de estudios o otro tipo de comunicaciones, llamadas, etcétera, que siempre que son menores, ¿no? Simplemente quiero añadir que creo que es muy importante llamar la atención sobre el uso y sobre todo el abuso de la prisión preventiva en los sistemas judiciales, porque en la mayoría de los casos es sinónimo de indefensión y utilización para otro tipo de presiones. Y creo que es muy importante que desde este grupo de trabajo se aborde la cuestión. Me reitero en el agradecimiento. Muchas gracias a todas y todos.
Thank you, Fernando. Thank you very much. In the meanwhile, I'd like to share a series of questions which actually are around the same issue. One by Eduardo Fleischner and another 2 questions by Rachel Brett, focusing on children of detainees. So one of the questions is, what are the collateral victims? What about them? The 100,000 children of the detainees? Could it be one of the most important factors in pushing the situation to change? And the second question focuses also on not only the physical impacts, but the emotional impact of uncertainty of duration and outcome of the incarceration of the parent, and also the restriction on visits and contacts. And there's a recommendation that any restrictions on family visits should not include children, but it should be taken into account separately, including taking account of the age. Maybe on this issue, I'd like to see if anyone from the panelists would like to give a few points, either an answer or add a comment. Diana, yeah, I know you've certainly got something to say about this.
Sí, crec que sí. Gràcies. Segurament, si algú altre dels ponents vol agafar la paraula en temes més tècnics, el que sí per experiència personal, els que no em conegueu, el meu marit està a la presó, però ha estat 2 anys en presó preventiva i tenim 2 fills. Per tant, el que sí puc respondre és dins de l'estat espanyol. És veritat que, com bé ja s'ha comentat, la presó preventiva no et dona accés a poder tenir aquestes trucades o aquests vis-a-vis extres. Per tant, tens, com tots els presos, la trobada familiar i la trobada convivencial amb els fills i filles. La presó preventiva, a més, sovint el pres, com que està en preventiva, no està fent la presó a prop de casa. Això vol dir que sovint en presó preventiva les famílies hem de fer molts quilòmetres per anar a veure el nostre familiar i això, en anar a la pregunta, en el cas de nens petits, doncs suposa, en el nostre cas, els nostres fills van estar 2 anys amb absentisme escolar cada cop que s'havia d'anar a veure el pare, en aquest cas. Per tant, aquí s'hi sumen altres motius en aquest sentit. Sí que hi ha recomanació de les presons en què els nens petits no vagin als locutoris, que són les trobades amb el vidre, perquè l'impacte de veure un familiar amb un vidre entremig i amb un temps tan limitat, perquè són de curs de 40 minuts o, bueno, depèn de cada presó, ja ho sabem, doncs té un impacte psicològic en el nen molt important. Per tant, la presó preventiva té un impacte molt gran amb els fills menors o filles, amb els infants, i és una de les qüestions en les quals s'hauria de remarcar més, com han comentat els nostres ponents a l'hora de fer aquestes accions no legislatives, que ens ha explicat la Jesca, també de formació i de prevenció. En el cas d'infants encara està més injustificada la presó preventiva i té unes conseqüències enormes i es vulnera un dels drets dels infants, que és el dret a estar amb el progenitor. I, per tant, en aquest cas, jo penso que és una de les coses que hem d'incidir, com deia la Jesca, no en la legislació, però sí en la formació, i insistir molt en el dret del menor de tenir el seu progenitor a casa. Segurament alguns dels ponents tenen més informació en temes més tècnics o jurídics. Jo tinc l'experiència personal i al final l'experiència personal també et fa coneixedora de les lleis, però sí que és veritat que la situació s'agreuja molt en casos de menors. Perquè, per exemple, un altre tema és que els pares, la persona major d'edat, el pare, no pot estar al dia a dia, no només en el seu dia a dia de creixement, sinó amb tot allò que l'involucra, sigui amb tutories, trenca totalment la relació de l'infant dintre la família i en el seu context. Per tant, en aquest cas és doble motiu perquè la presó preventiva no sigui executada com es fa en molts casos.
Thank you, Diana. Maybe another comment that I'd like to bring from Rachel Brett, which is more a comment than a question, but relates to the issue of alternatives, such as Jesca also described them. And she urges us to pay attention to the fact that certain countries charge for electronic surveillance, and that implies a form of discrimination against the poor and the marginalized. The same goes with bail, that many of the more disenfranchised cannot afford, and the technical accessibility of alternatives. So she points out that alternatives should not add to discrimination. I think that's an interesting point. I'm looking to the time because, yes, Laure, please.
Yes, I'd like to really support Rachel's concern about promoting alternatives to detention for 2 reasons. First, that it is well documented in Belgium, for instance, that the promotion of alternatives to detention has actually contributed towards replacing release rather than replacing detention. So there's a risk of net widening where judges are using alternatives instead of release rather than instead of detention. So first word of caution. And second is that what Rachel is pointing towards is that the promotion of alternatives, which involve generally electronic tagging, for instance, that means that there's an assumption that the person has a house and financial means to support themselves, or a family that can support them, or close ones who can support them, or bail. So all of this means that there's an assumption that the person has the financial resources, and the concern here when we see that our prisons are sadly filled with people who are vulnerable, who are marginalized, who have mental health issues. We see the number of undocumented people, for instance, in our prisons. This would mean, by promoting alternatives, that we'd be leaving out the most vulnerable people who do not have the resources to access these alternatives, and therefore perpetrate the discrimination that we already see in our criminal justice system. So that's a real, I would be very, very cautious around promoting alternatives to detention, rather than tackling the use of detention itself and any measures that restrict liberty. And the other point as well that I wanted to respond to, if I may, just very briefly, is that we do have, of course, the standards from the European, from the Strasbourg Court, from the CPT, but the EU has a very important role here in clarifying, making these standards more comprehensive, more readily accessible. We always hear how difficult it is for judges, for lawyers, to access all of these different legislative, this jurisprudential and other standards that are being developed. So the EU has an important role in making these standards more comprehensive and also more binding, and giving them teeth, because we see time and time again that pilot judgments, for instance, towards Poland 10 years ago, over 10 years ago, around the overuse of pretrial detention, has not had impact. We see the rate increasing in Poland once again, despite violations established by the European Court of Human Rights. So the EU has a key role to play as well in making these standards much more binding and enforceable for member states. Thank you.
Yes, Vania. You have to activate your microphone.
So here it goes. I need to get a remote. So just to pick up on these points, in regards to children, yes, I think we should have their rights into account, but often in practice, this is not in the minds of the judges ruling on pretrial detention or of the lawyers. So it's also a matter for the lawyers to push for that, except in extreme cases where the person has 10 children, or a child has no one else to take care of him or her. But it is in practice not always duly taken into account, and we should push for that to be the case. In terms of alternatives and of the jurisdiction or the competence of the EU to legislate, or the need to legislate, and what type of measures, and I think we should really address this issue at a general level of people who live abroad or who are foreigners within the EU, and to seek ways of changing the minds and the procedures. Because there are ways of finding people that are quite effective, namely via the Schengen information system, where you can use a whereabouts notice to find someone. And then often, instead of using the default position, which judges tend to use, and prosecutors, which is basically the person is abroad, issuing a European arrest warrant and detention and pre-trial detention because there is a flight risk because the person lives abroad, which is not correct as I see it. There must be a change of mind, of procedure. We need to act in a criminal case, looking at the EU territory as rather a unified territory. So to use measures that allow also to avoid pretrial detention just due to the exercise of freedom of movement. And this includes not only alternatives to detention, but also basic procedural measures, how to find people, how member states can communicate where people are registered at, where do they live. And this is touching upon, of course, procedural rules, but also attitudes and practical operation of proceedings. And I find it is quite hard to change minds and operations without a very intensive effort. It is difficult to create recommendations at EU level or Council of Europe level, and then to bring this to the judge's table, who is deciding very swiftly on pretrial detention. So this really requires a very intensive effort, and legislation does not solve everything, but it can help. So maybe we should use this link of the cross-border issues to at least try to link this to the issue of the excessive use of pretrial detention for foreigners or EU people living in a different EU member state, and to try to reduce pretrial detention also using that avenue.
Thank you very much. There are a number of questions that we haven't yet addressed. One I think would be interesting for another talk on remote hearings, the opportunities, but also the great risks, because I think that's something that many of you around the table are aware of. Another question that was also raised was about the added discriminate use of pretrial detention for people from migrant backgrounds or with diverse religions, ties with abroad. And I think, Laure, you were answering to that, but that's also, I think, a very important question, but that we'll have to address in a later stage. Time is running fast. I'd like to give the floor to Saskia Bricmont for the closing remarks. Saskia is a member of parliament for the Greens EFA group for Belgium, and I'm very happy to hear you for the closing remarks.
Eh bien, merci beaucoup Florence, et merci à vous toutes et tous qui participez à ce webinaire. Je pense que les échanges ont été extrêmement riches et on voit que les questions continuent. Je pense qu'on pourra aussi envisager d'y répondre par écrit, le cas échéant, pour continuer les échanges. Je voudrais d'abord remercier ma collègue Diana Riba ainsi que Prison Insider Fair Trial pour l'organisation de ce webinaire qui contribue évidemment à notre réflexion et à notre travail pour faire avancer la législation au niveau européen. Et on l'a vu tout au fil des échanges, cette question est éminemment européenne. C'est la question de la surutilisation de la détention préventive touche l'ensemble de nos États et a des impacts considérables aussi sur la coopération judiciaire en Europe. Donc, on doit s'y atteler à notre niveau. C'est une exception, ça a été mentionné, mais qui devient malheureusement une règle, un usage trop courant, et donc on doit absolument s'assurer que ce soit réellement un dernier recours dans la prise en charge pénale, puisque on sait qu'un tiers des personnes en détention le sont en attente de jugement. Et en Belgique, mon pays, la situation est similaire. On l'a entendu aussi de la part des différents intervenants, cette situation a de lourdes conséquences sur la problématique de la surpopulation carcérale, mais aussi en cascade des conséquences sur les conditions de vie dans les lieux de détention et sur les relations familiales et sur les enfants. Ça a été dit aussi dans l'échange, dont les droits ne sont pas respectés. Donc c'est aussi un angle par lequel nous pourrions prendre cette question. On est tous d'accord pour dire que la pandémie a quelque part ouvert la voie aussi vers peut-être davantage de réflexion et de prise de conscience, mais malheureusement avec cette ouverture vers la baisse de la surpopulation carcérale que l'on avait vue au début de la pandémie, qui revient aujourd'hui à des taux similaires. Or, on a vu que les alternatives sont bien possibles. Donc, la clé réside dans ces alternatives. Elles ne font pas tout, mais c'est une grande partie de la réponse. Et donc, il est encourageant d'entendre que la Commission européenne avance dans ce sens et soit partante pour travailler avec nous au travers de notre groupe de travail parlementaire qu'on a mis en place aussi pour y travailler. En décembre 2019, ça a été mentionné, sous la présidence finlandaise, le Conseil avait émis des recommandations, des conclusions ambitieuses sur les mesures alternatives à la détention. Encourageant son développement, il faut désormais assurer que ces recommandations soient suivies des faits et que les mesures soient encouragées. Plus largement, Laure l'a évoqué, il faut aussi que nous menions une réflexion sur le sens des peines et sur le sens de la détention. La question plus large de notre modèle pénal est en question de la sanction, du sens de l'enfermement qui doivent être traités avec sérieux pour construire de nouveaux lieux, construire de nouveaux lieux de détention ne fera pas disparaître les problèmes, mais interroge réellement notre vision que nous voulons pour le système pénal et la vision de la société que nous voulons. L'UE, je pense que c'est la principale conclusion que l'on peut tirer de nos échanges, doit se doter d'un cadre juridique contraignant, c'est vers ça que nous voulons avancer sur la détention préventive. Le commissaire à la justice, Didier Reynders, l'annonçait lors de son audition en début de mandat. Et la recommandation du rapport de Fair Trial va dans ce sens également. Il est indispensable d'apporter cette clarté sur le cadre existant et de le rendre obligatoire dans l'ensemble de nos États. Donc finalement, une directive sur la détention provisoire dans l'Union européenne serait la bienvenue. Nous y travaillons de concert avec le groupe des Verts, avec le secteur associatif, les ONG, que je remercie encore pour le travail effectué, pour le travail que vous êtes prêts à mener avec les parlementaires de différents groupes politiques. Et bien entendu, à nouveau ma collègue Diana. Donc merci à toutes et tous. Ce n'est pas la fin, puisque c'est une série de travaux que nous continuerons à mener au fil des mois et sans doute des années de travail au Parlement européen. Merci.
Thank you very much, Saskia. Indeed, thank you to all the panelists. We're coming to a close. I would like to suggest that you stay tuned for the upcoming webinars. You can register or sign up to Prison Insider's bi-monthly newsletter. It's published in English and Spanish and in French, and on prisoninsider.com. You can just sign up there. I'd also like to flag a series of publications that will be starting in the coming weeks in partnership with Prison Insider and the ICPR, the Institute for Crime and Justice Policy, around a series of research and policy work that they've done. And we will be publishing expert insights, film conversations, and all this will be available on our website, but also through the newsletter. So do sign up, follow us on prisoninsider.com and on prisonstudies.org, and stay tuned for the next webinars. It was a pleasure to have you all. Thank you very much. Goodbye.